All right, welcome back, ladies and gentlemen, to another episode of Lassiter Law. I'm here with my producer and co-host, Lacey G.
And I'm here with the very talented Mark Lassiter, and I'm interested to know what we're going to talk about today.
Today, even though we've been talking about DWI for quite a while now, and I promise we will move on to another crime, but DWI is just one of those elements and crimes that have so many different parts to it. It's actually, if you can believe this, Lacey, more difficult to defend a DWI properly than a murder.
Wow. Why is that? Just why?
So DWIs have a lot of scientific evidence that goes into them, which you don't have on every murder case. Most murder cases are predicated on evidence, which they should be, and there's a motive. And usually it's pretty easy to figure it out because you have certain people that are involved with the murder and that or likely to have been involved due to the motive, right? And then you have forensic evidence that tends to support a theory of the case, whatever that happens to be. With DWIs, you have stages in which if you do the work properly as an attorney, you must know, like, for instance, you need to know everything about search and seizure law, right? So that you know that the stop was valid. Then you need to know all about field sobriety tests because you need to know if the officer did them right and what the defenses can be for that. And then once they get on to breath tests, you need to know everything there is to know about breath tests so you can defend the breath test and become your own expert because many times your client can't afford an expert. And then you need to know everything now about blood tests because the blood test isn't always done right. It's usually very high, doesn't really reflect what your client looks like. And we'll get to that later on in another episode. But all of this to say is that you need to know a lot more about the scientific evidence that they're going to present in a DWI case. And that training is constant because it's constantly evolving. Whereas in a murder case, you typically have a very clear showing that the evidence indicates it's this person, or it's a he said, she said, which isn't that hard. And even if we're talking about a sex case where it's like a rape or something like that, most of the time, there's not going to be a dispute on the DNA evidence. Either the DNA indicates that that's the person that actually had intercourse, and then it's a he said, she said on consent, or the DNA indicates it's not the person at all. So, DWI is one of those crimes that I would say that most lawyers don't actually have the experience and training to actually properly defend them.
Because you have to do a lot of attention to detail. You have to know all the laws involved, like you said, and really do a lot of work on those cases.
That's right. And if you don't know those things and you don't do the training, you don't go to refresher courses, then you don't know the latest iterations, right? Because field sobriety testing has changed over the years. So that's what we're going to talk about today is standardized field sobriety testing. And before we get to that, we need to know what are field sobriety tests, right? So, Lacey, just commonplace, you've never been arrested before, but I'm sure you've heard that people talk about field sobriety tests. When I say that, as a layperson, what comes to mind?
ABCs backwards, walk a straight line, maybe stand on a foot.
That's exactly right. And you started exactly the way that everybody starts, the ABCs backwards. Ladies and gentlemen, field sobriety tests have never and will never have the backwards ABCs.
Good, because right? I cannot do that right now.
Nobody can do that right now, it's insane. But I don't even know how that rumor got started, but it has promulgated across the nation. Everybody thinks that's what the officer is going to ask you to do. So let's start with the easy stuff, right? We've talked about what happens, what you should do if you are detained, right? And you believe you're being investigated for DWI. Refresher, you say, with all due respect, officer, I'd like to talk to a lawyer first. When he says, no, you don't have that right, or he says, why would you want to do that? You just say, I'm not comfortable answering any questions without a lawyer present. They're going to tell you don't have a right to one at that point because you're being investigated, and you say, with all due respect, I don't want to do anything then. All right.
And then you are going to go to jail, but you need to not be sassy.
More than likely, you just accept it and say, look, you didn't give the officer the evidence that he was looking for, or as you will learn today, you didn't give the officer evidence that he can misinterpret.
Okay.
And that the jury has a likelihood of misinterpreting because the officer misinterprets the information, because the officer doesn't know all the ins and outs, because officers are only given a 3-day, 72-hour course on DWI. When they are trained as officers, that's what they get. Most of the officers only have that training. So when we talk about, do you, the layperson, have any more training than the officer? Well, the only thing he did was a 72-hour course. Literally, it's like take any 72-hour course, TABC related, right? Do you remember any of that at any point in time in the future? No, you do not, right? And you certainly don't keep up with it. So to say that these officers have specialized training is stretching it a bit.
And let me just ask, you said there's intensive training and knowledge to be able to represent someone with the DWI. Did it take you more than 72 hours to investigate and learn all of this information?
Absolutely.
Okay, I thought so.
You'll go through the training that they go through. That's one of the things that I would advise most of the attorneys to do is if you're going to represent people on DWIs, do the training the police do. Go to the same school. There are people out there that teach standardized field sobriety test courses and sobriety testing, and you go to that course, you'll take the test. It's not hard, right? It's super simple. Like,
can anyone take it, or is this just cops and lawyers?
Anybody can take it. All right.
I'm probably not, but I was just curious.
But the whole point of this is it's not a difficult course, and unless you're doing it frequently, you're going to remember the basics. But that's all the officers really remember too.
Hey, podcast idea. Actually, I might take it. We'll see.
Well, there we go.
We'll see if that's something I should take in the future.
Then we'll come in and we'll say, we'll see if you're an expert.
Yeah.
Right? And then I'll cross-examine you and see if you really know your stuff.
Yeah.
But after doing that, the attorneys can also take refresher courses. I would advise taking courses that have marijuana involved in them, drug DWIs, because there's going to be a lot of those. And that's another aspect. In order to represent people on DWIs, you often need to know the drugs and their effects and the half-lives. And basically, you have to become a lawyer scientist, right, in order to properly defend a DWI, in order to have that knowledge. Or you need to bring in an expert that has that knowledge, and so you don't have to. But let's just take the first thing that you said, which was ABCs backwards. All right, so ladies and gentlemen, likely after you're pulled over for DWI, if the officer detects the odor of alcohol, that is what is going to trigger the DWI investigation. Now, if you're pulled over anytime after 9 p.m., the likelihood is the officer is going to investigate for DWI whether you actually are or aren't. However, if he smells the odor of an alcoholic beverage, that is what is going to trigger his question, which is going to be, have you had anything to drink tonight? Sometimes they ask it even if you haven't had anything to drink. They'll ask you, hey, Lacey, have you had anything to drink tonight? The moment you say, yeah, I had one glass of wine, all right, step out of the car. Because we're going to investigate for driving while intoxicated. Again, DUI in other states, driving while intoxicated in the state of Texas. So one of the things that I like to start with is, okay, what does the odor of an alcoholic beverage smell like, Lacey?
Alcohol?
Yeah. What does alcohol smell like?
Alcohol. There's really no other.
There is no smell. You know what you're smelling?
What?
The mixer.
Okay.
You're not smelling the alcohol. They come in, you know why they say they reeked of whiskey?
Why?
Because he reeked of the smell of whiskey, not of alcohol.
So what's that potent smell then? It's just the mixers? Like you have a similar smell with sanitizer or something.
That's straight alcohol that you're talking about. You're talking about like 100 proof.
Okay.
Right? So it's important to understand what alcohol is. If you're drinking a whiskey or a vodka, it's like 40%. All right? You ever smelled vodka?
Yes.
What does it smell like?
Vodka?
No. Doesn't smell like anything. There's no smell. You combine it with cranberry juice and you get a Cape Cod. What are you smelling? You're smelling the cranberry.
Okay.
You mix it with a screwdriver. You're smelling the orange juice. Okay.
I think I might need to go take this field sobriety test.
Well, they don't teach you
something.
that. That's actually not one of the things. That's the funny part.
Because I'm failing right now.
What we're talking about is how does the officer even get to the field sobriety test, right? So in order to get there, he has to have a basis for believing that you're intoxicated. And they always use as this basis odor of an alcoholic beverage. And so if I'm cross-examining an officer, one of the first places I like to start with, okay, you smelled the odor. What did it smell like? Just like you, they can never describe it.
Mm-hmm.
Was it sweet? Was it sour? Was it salty? What was it? Like, describe it for me, officer. They'll never be able to do it.
Mm-hmm.
Do you know why?
Because alcohol is odorless. And
Because
what
they're smelling the mixer.
Mm-hmm.
It's like you're describing Diet Coke, right? How would you do? Let me ask you, if you were to describe the smell of Diet Coke, how would you do it?
It smells like soda.
Yeah, it's impossible. What does soda
Yeah.
smell like?
Diet Coke,
Right?
Dr. Pepper.
Like we're
here
going in
Texas.
this vicious circle right
Yeah.
now, right?
Yeah.
So if I were to smell like a Dr. Pepper, right? If your breath smells like Dr. Pepper to me, I think about the taste of it,
Mm-hmm.
right? And if you think about the taste of it, it's very sugary. And you would combine that with, there's like this, it's like a double espresso shot of sugar combined with corn syrup and a few other things. And it makes your breath smell, and I would say very sweet,
Mm-hmm.
you know, like you've just eaten a piece of candy or something like that, like chocolate. That's how I would describe it. But if you ask an officer to describe that smell, when you combine it with whiskey, see, whiskey has a distinct smell, because you ever heard of like whiskey that is sour mash?
No.
Okay. Have you
I'm
ever
not a
drank
big whiskey
wine,
drinker. Yes,
right? Let's
yes.
talk about wine, right? Have you ever seen them like swirl it around and sniff it?
Mm-hmm.
Why are they sniffing it?
To smell the alcohol.
To smell all the different additives, not necessarily the alcohol.
Okay.
The alcohol is the fermentation, but they're like, oh, it smells so oaky. You know, there's
Yeah.
cinnamon in here, right? Something ridiculous, but they can actually smell those things.
Mm-hmm.
So that is what the officer is smelling,
Okay.
right? I would say for the lawyers out there, you know, if you want to have a little fun, ask them to describe the smell, especially if they're new, they're never going to be able to do it. And then you just kind of, it's kind of a moot point. It doesn't really matter, but you're illustrating to the jury that the officer really doesn't have a good grasp of what the odor of an alcoholic beverage actually is. And they always say, oh, the odor was strong. Okay, well, if it's so strong, describe it to me.
Mm-hmm.
And then when they can't describe it, you're really illustrating this officer might be just making something up, right? If I were to describe to you what a cigar, if you smelled somebody and they're like, hey, or even better yet, do you have coffee in the morning?
I do.
Okay. When you wake up and they have that commercial, you know, wake up, Folgers in your cup, right?
Mm-hmm.
What is that smell that permeates? Like, I love the smell of coffee. So what does that smell?
Coffee.
Right? But what does it smell? I mean, you
Like
describe it, hey, it
coffee
smells
beans.
like.
Yeah.
Right? It's the coffee bean. It's the heat, and you add to it, it's like a flavor that you can almost taste in the air,
Mm-hmm.
right? There's a strong smell of coffee. And for those of you who drink coffee maybe way too much, I have this thing where I get around you and I'm like, holy moly, that person has dragon breath. Right? Have you ever run into that? Where you
I've
look
run into bad breath people for sure.
right, and their teeth are all stained and nasty,
Mm-hmm.
right? And you know it's from coffee because that's what it looks like.
Yeah.
And it smells like the person just ate a pile of poop. You know? That's a strong smell,
Mm-hmm.
right? That is the smell that this officer is claiming to have. So if you want to cross-examine the officers, lawyers out there, what I would suggest that you do is start them off with what's the smell like, then compare it to somebody who has bad breath. And like, you know, when they have bad breath, you can smell what it smells like, a pile of poop. Describe this. They won't be able to do it. And so you can illustrate that maybe this smell is kind of an imaginary thing.
Mm-hmm.
And they're just kind of, you don't have to say that it's imaginary. Instead, imply it by your questioning, right? So let's start there. Odor of an alcoholic beverage is how they get you to get out of the car, whether that's by admission or their claim to smelling it, right?
Mm-hmm.
And beer has a distinct smell too. And I would say that's the yeast, and that's the person that puts the flavor into that particular type of beer. But let's say that you have the smell, Lacey, all right? After he has the smell and he asks you to step out of the car, what is he looking for?
Signs of intoxication.
Signs of intoxication, exactly right. So if I were to ask you to step out of the chair, or if I were to step out of the chair, it's kind of like stepping out of the car. The officer is looking for whether you open the door without fumbling, right? He's looking for if he asked you for your license and insurance. You know, ever heard everybody say it's like license and registration in the movies all the time?
Mm-hmm.
Such nonsense. Like the movies get it wrong. I don't know why they just license and insurance. That's what the officer is looking for. And most of us have our insurance on our phones. So he's looking to see if you can hand him your license correctly and give him your insurance. I can't tell you the number of people that hand the officer a credit card. They're like, here. And the officer's like, clearly they're intoxicated. They hand me a credit card when I asked for their license.
But what about nerves too? What about you're just nervous being
Nerves play into this.
around
But
an officer?
let me just tell you, if you're nervous, right, and I ask you for your driver's license, why on earth would you give me a credit card?
Because I unintentionally make things awkward all the time.
All right.
So it
then
would
you're
just
leaving.
be, nerves. Just
Yeah, you're leaving that to me to explain.
Frantic, yeah.
Right. I have to then go to the jury and say, hey, she's nervous. Of course she's going to hand a credit card. Like that doesn't always fly.
I'm like a chihuahua. I'm a bundle of nerves at all times.
So
I
you're
just
just
hide
yapping all the time?
Yes.
Is that what you're trying to say?
Yapping
Nipping
and
at people's
nervous.
heels. But, you know, all of this, and we haven't even gotten to field sobriety tests, and maybe we'll save the field sobriety test for the next one because it is going to take some time to get there because we need to know first the non-field sobriety testing. What is the officer looking for? So maybe on this session, we're going to concentrate on that a little bit, and then it gets into the field sobriety testing. But all of this is tailored to why and how does the officer have enough information to arrest you? So we've covered odor of an alcoholic beverage. The other thing the officer is looking for is how do you react to a license and insurance question? And many times they'll ask you where you're coming from, right? Now, what do you think they're trying to get from you when they ask you that question, Lacey?
Damaging information.
That's
They want
exactly
to know
right.
if you're leaving dinner, what you've had to drink, anything like that.
If it's 2 a.m, where are you likely coming from?
So I used to work in morning radio and I would be on the road 2:30, 3:30, 4:30, just all the different times. I got pulled over one morning and they asked me, well, what are you doing out so late? And I said, not so late. It's so early in the morning. I'm heading to work. I thought because I wasn't drunk and I wasn't drunk, I'd be waking up. I thought I wasn't going to get a ticket. No, they still gave me a speeding ticket.
But it sounds like
I'm not what you're looking for.
Walk us through that situation. It's a perfect example. So what time in the morning was it?
Somewhere between 2:30 and 3:30.
All right. So about the time that the officers are expecting a person to be driving home drunk, right? Keep in mind, ladies and gentlemen, if it's anything past midnight, they suspect intoxication. And if it's anything past midnight, that's what the jury's going to suspect too. They're going to wonder, why are you driving on the road so late, right? Where are you coming from? And the officer's asking a legitimate question. Where are you coming from? And you said, what, home?
Yeah, I'm coming from home. He wanted to know why I was out so late. And I said, not so late, so early. I'm on my way to work right now. I'm leaving from my house.
And did he ask any other follow-up questions?
I don't remember. It was a long time ago, but I really thought I would get out of it because I'm not the person that you're looking for. You're looking for drunk people. It is drunk hour. You're looking for drunk people on the road.
I'm guessing he asked several other questions trying to see if you would give an answer that didn't make sense.
Yeah.
Right. So the officers do this a lot. What they'll do is they'll ask you, hey, you know, where are you coming from? Let's just pretend on that example, you're coming from a bar. All right. So you say, well, I'm coming from this establishment. So hopefully you didn't say the bar. I'm coming from the bar. No. Right. Coming from a restaurant, whatever. Let's just say it's 2:30 in the morning and you're like, I'm coming from this bar. Right. The officer's like, okay, do you have anything to drink? Right? They're looking to see if you had anything to drink because what they're trying to do, remember, if they're going to say that you have the odor of an alcoholic beverage, they need to substantiate that in some regard. By your admission, if you admit to drinking something, then that validates, hey, I smell the odor of an alcoholic beverage, right? Now, a question I run into or get asked a lot is, should you lie? Right? Should you say no? So that's the ultimate question, right? Because if you're answering questions, you've already done what I've told you not to do. All right. So let's get past this point that you're already in an area where you shouldn't be. So when the officer asks you the question, have you had anything to drink tonight? And let's be fair, if the first thing out of his mouth is, hey, can I see your license and insurance? You give it to him and he goes, hey, have you had anything to drink tonight?
I would say no.
You would say no. Now, if you've had nothing to drink, that's absolutely the correct answer. If, let's say you have had something to drink. Now, we've covered this. You say, well, officer, I really don't feel comfortable answering a question like that without an attorney present. He's going to assume that means you've had something to drink. But if you've already answered it in that way, stick with your answer. Well, if you're not going to let me talk to my lawyer, then with all due respect, I'm not going to answer any other questions. I'm not going to do any of your tests. All right. Moving past that, let's say that you answer the question, that your intent is to answer the question no matter what. Should you lie? Whereas I can never tell a person I advise you to lie. I don't advise admitting to the consumption of alcohol, because the moment that you do that, especially late at night, he's going to pull you out of the car and he's going to have you do these tests, which we're going to talk about in the next session, which, if done even properly, he's going to find a way to say that you didn't, right? And so he's going to find a basis by which he can arrest you, because he's arresting you on a basis of probable cause, not on beyond a reasonable doubt. So the answer that I would give in that specific example, if I were forced to answer the question, is if I had just come from a establishment, right? I might say yes. And then if he asks, well, how many did you drink? Right? Then you can see how if you don't answer the question properly the first time, it's going to lead to follow-up questions, all of which it's kind of hard to say no at that point, or why are you saying no, especially if the lawyer, if I'm hired, I just want to say he's not intoxicated or she's not intoxicated. Here, you can tell by these things. Well, why didn't they answer the questions is going to be the first comment, right? You don't have these answers, ladies and gentlemen of the jury, if I'm the prosecutor speaking, because the officer asked them and he just wasn't able to get an answer. That's not commenting on the Fifth Amendment, because in the video, you can see the officer's not able to get an answer. All right. Bypassing all of that, the answer that is most common that I get is, yes, officer, I had 2 drinks. It's almost cliche at this point. Everybody's had 2 drinks, right? Now, once you admit to consuming alcohol, the question the officer should ask, and is probably the most important question to ask, is, when did you consume those drinks? And most of my clients, when they give the answer of 2, they always say, well, a few hours prior. That's the wrong answer. Because first off, you're probably not telling the truth about the 2 drinks. And second, you're trying to make yourself sound better by saying it was a few hours prior. When at the end of the arrest, they're going to ask you to provide a sample of your breath or your blood. And if you don't provide, they're going to get a warrant and they're going to get your blood anyway. And the blood is going to reflect something, and they can do something called retrograde extrapolation. We'll talk about that another day. But at the end of the day, they'll be able to disprove your 2-drink synopsis, right? So if you're going to tell them anything without saying, hey, I drank 11 beers or I drank 5 drinks or something like that and 7 shots, right? What I would keep it at is simple, is if you admit to drinking, you need to, even if it doesn't sound good, follow up with, when he asks when, you can say, I'm not sure.
Okay.
That's a really simple answer. It's not untrue. He may try and nail you down. Well, was it 30 minutes ago? Was it an hour ago? You say, I'm not sure. Because then they cannot use the retrograde extrapolation, because they need certain information to do retrograde extrapolation. And one of those things, and the most important of which, is when was the last drink consumed? Okay. Other than that, they can just provide a range of how many drinks. So getting back to what happens after you're pulled over, Well, after they've talked about the odor of an alcoholic beverage, if you admit to it, even if you don't admit to it, and you say no, if he smells it, he's going to get you out of the car. So let's get back to what's he going to do then? A lot of the times they will give you the ABCs. Now you believe, and everybody hears it's doing it backwards. It isn't, all right? What they do is the officer will ask you, in fact, why don't we do this?
Quiz time?
Quiz time.
All right.
We're going to give it to you, Lacey.
Mm-hmm.
All right. So I'm going to give it to you just like the officers give it. So you, the audience, can see this is what you should expect at some point during a field sobriety testing where the officer is trying to get an idea of whether or not he should or should not arrest you.
I'm a ball of nerves. Let's go.
Yep.
I can do this.
Now, the first thing to know is this is not a standardized test. It is not given in every instance, but it is an excellent indicator of intoxication, in my opinion. In fact, the jury will pay attention to this more than the field sobriety test, the standardized tests. So I'm going to say, I'm going to pretend I'm the officer. I'm going to like, Lacey, I'm going to give you a test. Do you know your alphabet?
I do.
What level of education did you finish?
College.
College. All right. So you finished college. Is it fair to say that you know your alphabet?
I do.
All right. So what I'm going to ask you to do is I'm going to ask you to start at the letter E. And I'm going to ask you to finish at the letter P. And I want you to say it without singing it. Do you think you can do that for me?
I can try.
All right. Begin.
E, F, G, H, I, J, K, L, M, N, O, P.
Right.
Nailed it.
You did nail it. All
Did
right.
I sing a little bit?
No.
I kind of, okay.
No, you did
I
perfect.
couldn't tell if I had the
All right.
cadence
And
or not.
what letter did I ask you to start with?
E,
And what letter did I ask you to finish with?
P.
All right. Ladies and gentlemen, that is an example of how the tests go, how this particular test goes. Now, what I see very often is people trying to sing it.
Mm-hmm.
Now, if you want to pass this test, guess how we learned it? How did you learn your ABCs?
Singing them.
Singing them.
Yeah.
All right. We didn't learn them by saying them. So that throws people off.
Mm-hmm.
There's a reason that they do that, because it does throw you off, especially if you're very nervous. You're not very nervous right here with me. You're just doing it and you nailed it perfect.
Mm-hmm.
If you did that, the officer would be like, okay, well, she did that perfect.
Let's try again.
Try
Let's do something else. Yeah.
Right? But to illustrate what I see a lot is that people, when they try and say it, they will not be able to start with, like in this case, the letter E.
Mm-hmm.
They will go trying to figure out, how did you get to E? If you were to do this test, if you decide to do this, now I decided to do no test, but if you decide to do this test, ladies and gentlemen, here's what I suggest you do. In your head, be singing it. When you say it, just be saying it. So I would be like in my head, A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P. Right? It sounds like you're singing, but you're not.
That's why I wasn't sure if I was or not. I was doing that in my head. Yeah.
No one can get upset at you by saying it. It's kind of like Frank Sinatra singing, right? Towards his latter years, Frank wouldn't sing. He would just say the words, hey, whatever it happens to be, whatever that song is, he didn't hold the note. He would just say it to the rhythm. People, when I was growing up, my mom made me memorize a whole bunch of stuff. And the way that she got me and my 6 sisters and brother to memorize things was by putting it to music. Because when you put something to music, you can do this test at home. You will remember songs, all the words to a song. But if you were asked to memorize that song just verbatim and just saying it, you can't do it, right? But I bet you could sing every Taylor Swift song there is, like on command.
I could most of them. Also, multiplication tables. That's how we learn multiplication tables in elementary school.
And
was putting them to songs.
There's a reason for that. Okay, so you will remember things the way that you learn them. You don't remember saying the ABCs, and that's why a lot of people screw up, because that's not how you learned them. So when you are doing the ABCs for the officer, sing it in your head and say it as you're singing it in your head, and you will do just fine. Where people screw up, and the reason they ask you to start on a particular letter is because when you sing, you start with A. You don't start with C or with E or with D, right? Which is a lot of the letters they use to have you start with, and you don't end. So just remember, you have to remember the start and the finish. Everything else will just flow naturally, right? But I get these people, they're trying to say it, they're already nervous, and then they're like, DFTPLOX. And literally that's an example of what I see. And I'm going, how did you screw that up so bad? And it's because they're trying to say it. And as their brain's trying to say it, they're trying to remember what letter they were asked to start and end with. And it screws them all up. Because have you ever tried to count like 1, 2 to 100? And while you're counting to 100, somebody throws in 31, 28, 52, and then you lose your count. Well, you're not drunk.
My memory, I mean, I wouldn't think that they would be coming back and asking me that, so I would forget immediately.
That's
what
exactly
letter.
Right. So that's what happens, right? And I'll give you another test. So after the officer does the ABCs, typically he follows up with a numbers test, right? And what he's going to ask you to do, and this is where they get it wrong, this is backwards. Lacey, I'd like you to start with the number 52 and end with the number 33. Do you think you can do that?
Maybe.
All right, let's see you try.
52, 51, 50, 49, 48, 47, 46, 45, 44, 43, 42, 41, 40, 39, 38, 37, 36, 35, 34, 33, I think is what you said.
That's
I
it.
forgot. Okay.
See, already you've forgotten, right? And you're not that nervous. But imagine doing that out in the field, outside of your car, with 4 officers around you and a big spotlight, right? It's kind of difficult. But that is what they expect you to do. And so that's the counting backwards test. Now, those things are not standardized, the ABCs and the counting backwards. But I have found that juries, they tend to believe that these tests are the most representative of whether or not you're functioning normally or abnormally.
Do you ever ask the jury to perform that? Do you ever put them on the spot and
I wish that I could.
Okay.
But all you can do is imply that if the jury were asked to do these things, that they would perform no better than your client did, especially under those circumstances. But you have to illustrate for the jury why that is. And you have to recreate the nervousness. And that is built into a good attorney's voir dire, which is jury selection. You explain to them how nervous a person would be. You ask the jury, hey, if anybody was pulled over, are you nervous at all? Why are you nervous? You get them to talk about it. How might that affect your mental abilities to maybe do things when you normally would be able to do them just fine? And so these are the questions that need to be asked in jury selection so that you're tailoring it to your case. So that when you make these arguments to the officer, for instance, cross-examine the officer, I'm like, well, did you know that memorization of these things is done by what? Because you don't want to have to ask your client. It's done by what? It's done by singing, right? Officer, you didn't memorize this in grade school by saying it. You memorized it by singing it. Are you aware that singing it is different than saying it? Are you aware that your brain will remember things better the way in which you learned them? So if you take away the way in which they learn them, officer, we would actually expect them to screw up the ABCs and the numbers, because that's not how we learn them. We didn't learn them numbers going forward, not numbers going backward. And the fact that we can or can't do that is representative of nothing. It is representative, ladies and gentlemen, nothing, because they're not standardized. And the reason they're not standardized is if you gave this to a group of 100 people, in order to be standardized, they have to get the same result, right? And in order to be indicative of intoxication or some type of impairment, these tests have to indicate on a regular basis, this person is impaired or intoxicated. They can't do that. Why? Because if you put 100 people in a room and you asked them to do those 2 tests, the chances are that they would screw them up. And therefore,
and
when
this is sober. You're not
sober.
Talking, okay, just
No
regular
alcohol,
people throughout
right?
the day. Yeah.
And so what they'll do is I'm sure they've tried to do this. They can do a study. Have you ever heard of double-blind studies?
No.
Okay. So if you do a study scientifically, in order to establish that this result is indicative of this condition, you have to be able to do that over and over and over again. And every time it ends up in the same result. That's called the scientific method, right?
Mhm.
That you can repeat the experiment. All right. So that means if I give it to a random person, it should work and that they should be able to do this. So if I were to do a study on the ABCs and the numbers and it was double blind, that means that the person that is doing the testing doesn't know if the person they are testing is intoxicated or not intoxicated. Because you're
Okay.
going to put intoxicated people in there and you can put non-intoxicated people in there. And that testing person is not allowed to know which of the two they are. They just give the test and see if it works or see if it doesn't, see if they can recreate the same thing over and over and over again. And I imagine what you would find is intoxicated people passing it and non-intoxicated people failing it, which means you cannot standardize it because it doesn't stand for anything. And ladies and gentlemen and lawyers out there, when you are cross-examining and if your client does poorly, you need to illustrate this. There's a reason this is not a standardized test because it doesn't work. It is not representative of anything.
So it's not standardized yet. This is a part of the standardized field sobriety test. They can still label it, call it that way, even though it's not scientifically verified that this works.
So what I'm describing right now are the letters and the numbers, and those are non-standardized tests. In other words, they are not used every time. They're not validated. They are not, the studies that are done on those things have not represented correctly or indicated that the people that fail these tests are intoxicated or not, right? It's just the studies have not indicated this is a good measuring stick, which is what you need as lawyers to illustrate to the jury is that these are not good measuring sticks. There's a reason that they're not used in every case, all right? But then again, you have to be able to, on the flip side, explain why the standardized test should not be used in every case. But we'll talk about the standardized here in the next session, but I want to stick with non-standardized testing.
Okay.
Because that's what we've kind of been on and what happens after you're pulled out of the vehicle. So just a quick recap. If you're pulled over, the officer will typically ask you about whether or not you've been drinking or not, right? Whether you say yes. If you say yes, you're going to get pulled out of the car more than likely. If you say no, then the officer is going to pull you out of the car if he smells the odor of an alcoholic beverage, all right? Now, let's say he doesn't smell the odor of an alcoholic beverage. Let's say you just put a stick of gum in, right, to mask that smell, or you sprayed perfume all over, right? The officer is going to say, well, I can't smell anything because the overwhelming smell of perfume or gum, which is indicative of a person that doesn't want me to smell their breath. That's what they're going to say, right? It's up to the lawyer to diffuse that. But then they'll ask questions. Once they ask those questions designed to get you to admit to drinking and when you drink, right? They ask you to step out of the car. When they ask you to step out of the car, Lacey, they are looking for any indication that everything isn't perfect. Like if you lean on the car, an officer will put leaned heavily on the front door to get out, right? Or leaned on the car for support as an indication that you might be intoxicated, which is nonsense, right? I'm sorry, when you get out of a car, guess what you do? You hold on to the door. Mm-hmm. Or you hold on to the little handle to get out because it's easier. But the officer will take any little thing that you do, and I mean any little thing that you do, and notate it as some sort of a sign of intoxication. Lawyers, you have got to be able to combat that nonsense. You have got to be able to illustrate, officer, it seems to me that you have marked down every little thing that the client did, that the defendant did. Now, I try not to refer to my client as a defendant throughout a trial. I always refer to them as a name. Do you know why?
Because you don't want to make them sound guilty by saying defendant, because that sounds like somebody did something wrong.
That's an excellent reason. And there's another reason.
Okay.
You've got to personalize your client to a jury. It's the same in hostage negotiation, right? They try and get them saying the name over and over and over again, because when you personalize a person, it is much harder to view them as an object.
Okay, that makes a lot of sense.
The jury has to view them as a person, not as an object.
All right.
All right. So you say the client's name, and let's just say Mr. Jones. And a lot of time, let's just say his name is Aaron Jones, right? I will use the first name to even personalize them even further, okay? So I will say, officer, when you were talking to Aaron, right, you notated that his answer didn't make sense of where he was coming from because he said he was coming from a friend's house and then he said from a bar. Let me ask you something, officer. And then he didn't get everything right as far as stepping out of the car. You notated that he leaned on it or he missed a number. Tell me, did you notate any of the things that he did right versus the things he did wrong, in your opinion? The officer's going to look at you like, what are you talking about? Well, when you're cross-examining the officer, it's important to show a jury that, or a judge, that everything that the officer says isn't necessarily true, that they are based on assumptions. You're like, officer, you notated that my client used the handle of his door getting out of the car, didn't you? Well, yes, I did. And the only reason you would put that in there is, to you, that might be a sign of intoxication. He goes, well, yeah, it could be. And it could very well just mean that he was getting out of the car too. And he goes, well, I don't know about that, because they'll never admit anything to you. Mm-hmm. And this is sometimes where I'll throw in, officer, as part of your training, did you take a class in testifying? They all did. Yes. Why would someone need a class in telling the truth? I'm confused, right? Use that to your advantage. Now you got to pick and choose when you use that moment. And usually I would do it after a couple of things and where I have shown the jury that this is an assumption. He's just making something up. So like, for instance, with the door handle, I would say it can be just as likely that that is an innocent, normal way that he gets out of the car as it is, in your opinion, an idea or an indicator of intoxication, right? And he'll say, right, because there's no other way for him to go on that. And then you say, look, I noticed that basically every time you saw an indicator of intoxication, you marked it down in your report. Fair? And he's like, yeah. Well, where are all the things that you put in your report that show that he's not intoxicated? Well, let's say he got his license and his insurance out correctly. Did you notate in your report, did this correctly? And when he was walking, outside of you giving him a bunch of nonsense tests, did he walk normally? Did you notate that he seemed to walk normally? Well, no. Well, officer, it sure seems to me that you take one side of the coin and everything that you want. We talked about this in one of our first episodes, confirmation bias. You have used them to show, hey, I believe he's intoxicated, so this must mean that. But you have not compared it. And what I like to do is I get one of those butcher blocks, big pad of paper. And what I'll do is I'll mark in there all the things that he did normal. And I'll put normal, 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 as many times as I possibly can. The only things, if you look at it, like on a test, if you get 90 out of 100 things right, what score is that?
Yeah.
It's an A.
Mm-hmm.
Well, find 100 things that he did right and then compare them against the 10 things that he did wrong. He gets an A, officer. Mm-hmm. He's got all these indicators of non-intoxication, and yet you only have these few things. In my book, and in pretty much everybody's book, that's an A. He passed it with flying colors. Like, this is a good grade. It's not even a B or a C, right? You can find those things. So write them down. Normal, 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 normal.
That's brilliant, Mark Lassiter. That's really good.
Those are few of the tricks that you can do. And it's not really a trick. It's just illustrating that they're not giving us both sides of the coin. Mm-hmm. And then you can ask the officer, hey, are there two sides to every coin? And he might say, well, we asked him to explain it. I was like, well, no, you really just interpreted things because in your mind, before you knew anything, once you heard he drank, that was it. I think he's intoxicated. And then every single thing from that point forward meant he was intoxicated, because there's no analysis done on an assumption. There's no factual basis that you can check and say he used this handle to get out of his car, right? Or he missed this number, or he skipped over this letter. There's no basis for you to say that means he's intoxicated, but that's what you're saying because you have confirmation bias. You're not able to, officer, step back and look at this objectively and say, look, look at this board. He did everything else right. That really doesn't mean what I think it means. But then you get to the point and you need to be able to illustrate this with the jury. I understand that you have a job. You have some indications and own it. There are some indications because he admitted to drinking or he missed a letter or whatever that ends up looking like he might possibly be intoxicated. You can't just let the person go. I get that when you make a decision, officer, and illustrate this, lawyers, when you make a decision, you're making it based on probable cause, right? Lacey, is probable cause, just to a layperson, the same thing as beyond a reasonable doubt?
No.
No, not even close.
Mm-mm.
And in jury selection, we make sure the jury knows, officer, probable cause is what it takes to arrest somebody, right? It's going to say right. And probable cause is the second lowest burden of proof we have in this country. The second lowest. Reasonable suspicion is one level below that, and that's it. And they're basically the same thing. It's specific articulable facts, able to form an opinion that this person might be committing an offense. That's probable cause. And so the officer then, you make an arrest, not because they are beyond a reasonable doubt, but because you had probable cause, right? And we don't fault you for that. Never call them a bad officer unless truly you have enough information there. Juries don't like that. But you need to be able to illustrate that this officer made his arrest based on a series of assumptions, because they're not going to have a breath or a blood test at that point. And so when they make that arrest, Lacey, you, the lawyer, if you're any good, need to be able to establish by that butcher block, by cross-examination alone, that they are making an arrest based on a very, very low standard. That they barely met is what you want to say. I understand why you arrested him. You had somebody that admitted to drinking, and even though they had a lot of things that indicated non-intoxicated, they had a few that did. But you have a standard of probable cause. It's not your job to sort that out. Your job is to arrest him, get him off the street. That's your job. And he's going to say yes. And then what have you established, lawyers? You have established that this officer barely had probable cause. And then in closing argument, you say, that officer barely had enough to even arrest him. That by no means gets anywhere near beyond a reasonable doubt. And we'll have a whole talk about burdens of proof and beyond a reasonable doubt. But when we're talking about DWIs, specifically in these non-standardized tests, you need to be able to illustrate the difference between an assumption and a fact. And when they have errors in their tests, the non-standardized test, talking, driver's license, getting out of the car, walking normally. And by the way, that's a big deal. You should always look at how a person walks when they get out of the car. And why is that, Lacey? Why would I care as a lawyer how you walk if they're going to give you a walking test later on?
Because you want to see if they have their motor skill functions.
Because I want to see if they're walking normally the way they normally walk. Because if they can't walk normally when they're walking to wherever the officer tells them to go, I really lose the argument that in the walking test, they're making them walk abnormally, right? What I want to illustrate is that outside of all of their BS tests, everything about them is normal. Because I want to write normal, right? And so when we talk about these non-standardized tests and the things that they're observing, we're really talking about observations. You don't have to illustrate this means they're non-intoxicated. What you illustrate is to the jury, you're going to show a fact. They walked normal. That is a fact or it is not a fact, right? What they take from that is up to them. But what we want to do is say, hey, if we were evaluating the case, and scientifically, we need to determine based on these few things whether or not a person's intoxicated. That means that they have to mean that every single time that person's intoxicated, the experiment is true. And if they cannot repeat that, in other words, if it does not mean that, with these characteristics, if it doesn't mean that they're intoxicated every time, then we are not beyond a reasonable doubt. We're at assumption, hunches, opinions. And opinions are like what body part? Everybody's got one.
I was
right?
going to answer. That wasn't a question for me.
We can say assholes. And I always say this to a jury, and I say it in front of the judge too sometimes. And I was like, opinions are like a certain body part. My dad used to say, everybody's got one, right, officer? That's what you have in this case. You have an opinion. Maybe right, maybe wrong. But the problem is, officer, that it may be wrong.
Mm-hmm.
Opinions are simply that. If you, as a lawyer, cannot illustrate to a jury that an officer is making an arrest based on an opinion and an opinion alone, then you should not be representing that person in a trial. Because that is the entire crux of probable cause. It's the officer formed an opinion. The moment you say the word opinion, you say is akin to what? An opinion is a assumption. It doesn't mean it's wrong. It doesn't mean it's right. But under the scientific method, if you cannot recreate that, and it means that every single time, then we cannot say it is right beyond a reasonable doubt, which means we have what? You're asking this jury to do what? Arrest and decide and find them guilty based on opinions that may or may not be right. And that is not our justice system. Remember, telling a jury that a person is not guilty is not the same thing as saying that they're innocent. The way I like to explain it to them is this. A lot of the time, especially with DWIs, because in certain cases, you want to allege innocence, but not in DWI cases, because there's always going to be some evidence of intoxication. You want to say, look, I understand that the officer had a right to believe and form this opinion. I get it. But if you return a verdict of not guilty, you are not saying that the officer's opinion was wrong. That's not what not guilty means. And you have to empower the jury this way, lawyers. You need to be able to tell them not guilty. All it means is that the evidence that they presented today or yesterday or all over the course of the trial simply didn't rise to the level of beyond a reasonable doubt. He well and truly might have been intoxicated, but if they did not prove it to you beyond a reasonable doubt, your responsibility as a juror is to find them not guilty. And it's not saying they're innocent. It's saying that the evidence that I have was not sufficient to prove it, i.e., every single time a person with those facts is intoxicated. If they can't say that, then they haven't proven their case. And because we know they can't say that, because we know based on the officer's arrest, it was an opinion. He admitted it to you. It's an opinion.
Very well said, Mark Lassiter. Very well said. That's incredible to be able to go there and explain that so eloquently. I'm with you.
Well, lawyers, if you're listening, you need to be able to do that. And ladies and gentlemen, lay people, if you're listening, your lawyer needs to be able to do that. If they cannot explain to people the difference between an opinion and a fact, then I don't know what they're doing representing defendants, right?
And that's why you should always investigate your lawyer before you just hire somebody.
Always. Make sure that, and especially in criminal cases, when we talk about, and go back and review the episode about hiring a lawyer, that lawyer in a criminal case needs to be able to talk to a jury. And if you get the feeling in the course of an interview that lawyer can't carry on a conversation, or you don't like him, and it's the first time you're meeting him, well, guess what? The jury's meeting him for the first time too in that trial. And if they're not likable in the meeting, chances are they're not going to be likable to a jury either. Doesn't mean they're a bad lawyer, but it does mean that they're going to have some issues in trial that maybe you shouldn't have to overcome. The lawyer you hire, you should not have to overcome their deficiencies. They should be good enough or good based on what they present to you, that's why I like to say, if the lawyer get in there and you start a conversation, if you get a feeling like, I don't really like this guy, well, chances are a jury's not going to like him either, right? And it's the same thing. If you carry on a conversation with a person, you know pretty quickly if they're likable or not, right? It doesn't mean you're going to like them down the line, but in that initial meeting, you kind of get a feel for that, and you have to get a feel for that. But going back to, we're talking about the non-standardized tests. The ABCs, the numbers, asking, about driver's license, insurance, and where you're coming from and how many drinks have you had. Those are all normal things. But there's one last thing I like to get to.
Okay.
And they ask it almost every time. And then the officers will ask you, the citizen, from a scale of 1 to 10, 1 being as sober, never had a drink, and 10 being the drunkest you've ever been, where would you rate yourself on that scale? Now, the problem is people tend to think in terms of, well, if I had 1 drink, I'd be 1. If I had 2 drinks, I'd be 2. If I had 3 drinks, I'd be 3. Don't do that. What the officer is trying to get you to do is admit to having some sort of abnormal functioning. Because remember, sober is dead 0, sober, no alcohol, and 10 being the drunkest you've ever been. If you even say 1, you are admitting that the alcohol you have drank has affected you at least to some degree. My answer in that case would always, 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 always be 0. If you truly feel that you're okay to drive, then you need to say 0 because the alcohol is not affecting you at all. If I have 1 drink and then I drive, the chances are that the alcohol has metabolized, I have processed it, and I have no alcohol concerns whatsoever because that 1 drink is not enough to make me feel intoxicated. So the answer is 0. You can have a drink and be a 0. You can have 3 drinks and be a 0. You can have 5 drinks and be a 0 based on the timing of those drinks. Ladies and gentlemen, if you are asked that question, 0 is the answer. Or simply don't answer. I'd like to talk to my lawyer, right? Which you should have said from the beginning, because each and every one of those things, if you give them, the officer, these things, the officer has a basis on which to arrest you. If you don't give him the answer to any of those things, let's just say from the beginning, you had taken my advice. You say, look, officer, I don't feel comfortable answering without an attorney when he asks you if you had anything to drink. And he goes, well, why is that? I'm sorry, officer, I just don't feel comfortable. You have the right to that. And he goes, well, I'm going to have to make a decision based on no information. Great. Mm-hmm. I know, right? And you're like, I'm sorry, that's just the way I feel, right? With the state of the police department these days, officer, you don't even have to give a reason. You say, I just don't trust officers. Okay. He goes, well, everything's being recorded. Yes, I know that. I'm grateful. I'm still not going to answer any questions. I've requested my attorney. Now, he has to make a decision based on 0 information. Tell me that's not the biggest assumption you could possibly make. He has no information of drinking. Well, he might have some bad driving. I don't know, depending on the facts. Well, let's just say you were speeding. He may or may not have the odor of an alcoholic beverage, which he cannot confirm. He has no basis on which to arrest. Give him no basis. But if you do those things, understand what they are, understand why he might be asking you. This is to give you information, ladies and gentlemen, so that if you are in that position, you know what you can or can't do. And let me tell you, you can refuse everything. Everybody says, I didn't know I could refuse. The officer's not going to tell you that. You can refuse each and every test that he gives you. The easiest way to do so is at the beginning by saying, officer, with all due respect, until I've spoken to my attorney, I don't feel comfortable answering any questions. Leave it at that. You have asked for your attorney. It's over. Don't let him convince you, well, if you don't answer my questions, then I have to arrest you. That's a tactic. That may also be true, but it is a tactic to get you to respond. Don't give him the opportunity, because if you have been drinking, and let's just say you might be intoxicated, the best way is to give him no information. Let him get the warrant based on 0 information. We can fight that. But if you give him the information, then you have given him the tools that he needs to prove his case. Now, it doesn't mean in every case that if you don't feel that you're intoxicated, you shouldn't answer all the questions. Like, for instance, let's say I had 1 drink, 1 glass of wine at dinner. Yes, I had 1 glass of wine at dinner. It was at 6 o'clock. I'm a 0 alcohol. This is what you should do. Ask him for a portable breath test. Portable breath tests are also known as PBTs. PBTs are usually kept in the trunk of the officer's vehicle. Even if they say we don't give PBTs, okay, well then I'm not willing to do anything else. I'm telling you I'm not intoxicated. I am willing to take a portable breath test that will prove, officer, I am not intoxicated. By the way, good luck remembering all this if you truly are intoxicated. But let's just say you aren't. I would like a portable breath test. It's not admissible in court, so you're not giving up any information that can be used against you. You can just say, I want the portable breath test. And when it shows zeros or 0.02 or 0.06 or whatever, you then have that information that you can use in your defense, but they cannot use against you. So if you are truly not intoxicated, don't answer their questions. Officer, I'm not intoxicated. Let me take a portable breath test. If he says no, well, I'm sorry then. If you're not going to let me prove my innocence right here and now, I'm not going to do anything else because you're not willing to do the right thing. And if he doesn't have one, go get somebody who does. It isn't that hard. You have like hundreds, thousands of people in sometimes in police departments. Go find me someone who does. It's not that difficult. Let me prove my innocence. How powerful is that? When you say it on camera, officer, I want to prove my innocence. Give me a portable breath test. And when he says no, okay, then you're not interested in truth. So that is a non-standardized sobriety test that you can request. The officer doesn't have to give it to you, but just know if you request it and he does, right? And then you get arrested, well, a jury's going to imply what that is because all they can hear about is that the PBT indicated the presence of alcohol because the PBT, even though it's a breath test, has not been scientifically proven to be reliable enough to be used in trial. All it can be used for is to indicate the presence of alcohol.
But you should only do that if you feel like you
feel you are not intoxicated.
Okay.
Don't do it if you're intoxicated, right? Don't do anything if you're intoxicated, right? Just ask for your lawyer and be done with it. So that's going to kind of wrap up non-standardized testing. In the next session, we'll talk about standardized.
Mark Lassiter, how do people get a hold of you?
You can reach me at 214-845-7007, or you can reach us online at www.lomtl.com.
The great Mark Lassiter, everybody.
ProPod Digital.